sometimes this change.
Yeah, this change with field is very different.
Supplementary cost list, item number 1.
May please, Lordship. In preferring the appeal, Lordship, there is a delay of 847 days against the impugned judgment, an order dated 16/6/2021, passed by the Special Judge Foxo.
What is the punishment?
Punishment is 20 years, Lordship,
20 years.
with fine.
Section 6.
Section 4, 3 and 4 of POXO Act.
4 is 20.
Lordship is given.
And 6
Maximum is 20, my lord. I think it starts with 10 to 20. I guess.
She was given ordered maximum
after
punishment.
the amendment.
After the amendment.
After the amendment.
Not less than 10 years, but which may extend to imprisonment for life.
Heard Mr. S.D. Opadia, led Legal Aid Counsel. On good grounds shown, the delays sought to be condoned in this petition is allowed. Petition disposed of. And so I also heard Ms. I know that somebody responded. The main case, registry is directed to diarize the appeal and give a number accordingly. The lower court records, trial court records hereby called for. Let paper book be prepared. The same to be done so within 6 weeks. This the matter thereafter.
Daily cost list, item number 1.
My lord, in the last occasion, the learned AG sought time for bringing instruction. Last of the date, my lord, 1st December 2023. Lordship, can you see the order?
Yes. This is a effort for settlement.
Effort for settlement.
May it please Your Lordship. Lordship, let the matter be heard on merit. Or if they want for settlement, Lordship, they can approach the government, Your Lordship. They can write and approach the government. If they do, if they so desire, Your Lordship, for settlement, let them approach the government, Your Lordship.
Well, in that case, my lord, let it be better clear. That means, my lord, they are not ready.
Not ready.
They are not ready. There is no question of approaching the government. Approaching the government.
No, we'll.
So may I? We can proceed on merits. Yes, we can proceed on merits. My lord.
So,
if Lordship permits me, I can start, my lord. Today.
Practically, I don't think it will be possible to finish within this year.
Can have after vacation, Your Lordship.
In that case, my lord, it is 6 years litigations, my lord, long pending matter. Anyway, my lord, just after vacation,
What kind of solution can be achieved if you contest the matter and hear on merit?
My lord, Lordship, my
Will we claim for damages or it will be?
Lordship,
my
in
lord,
fact,
we have a my lord, entitled for compensation.
If you make out a case for damages,
Yes.
can this court grant that relief?
My lord,
It may direct you to the appropriate authority.
my lord, damages they have calculated, and single bench directed them to pay the damages in case after land survey my land is not under submersion. Now they have complied with the single bench judgment. They have conducted the survey and found my land is submerged. And single bench said that if you find that land is under submersion, you have to acquire it. Now, the consequential of the compliance of that order is to acquire the land. Now they say that it involves a huge amount of money. We don't have. Therefore, we rather prefer to dismantle
challenging
it.
single bench judgment or not?
Yes, single bench judgment. Single bench judgment. We challenge a single bench judgment. And now, therefore, they want to dismantle the dam. Now, dismantling the dam will cause a huge amount. Therefore, the party thought it over. We appreciate the difficulties of the government. We have on merits. But even if Lordship allow them to dismantle it, damages they are bound to pay. single bench judgment, they didn't go for challenges also. And they calculated the damages also. 2011, they're bound to pay that one. Now, our contention is that we entitled for compensation, number one. Even if, my lord, compensation is not entitled, assuming do not admit it, damages is the must. And damages, they calculated 6 crore that time in 2011. Now, that was the damages occurred in 2011. Now, from 2011 till today, continuously they are deprived. The land is under submersion. The damages will come. So therefore, my lord, we make a statement, give a response to the report given by the state government that even since they say that we don't have the money, 78 crores, therefore under the JJM scheme, we have a 32 crores. Therefore, we prefer to dismantle it and launch a new greenfield project in the area. Therefore, we are saying that, okay, instead of dismantling it, paying the whatever damages to me, and you dismantle and go for construction will be more or less the same thing. Therefore, we are even ready to accept to have a balanced settlement. You pay the JGM scheme that money along with the damages and settle once and for all. That statement we have given in the affidavit. Therefore, the AG sought instruction from the government whether they are ready or not. Now, because of that, Lordship posed the matter today. And if they are not ready, then
we'll hear the matter
will be heard on merits. Just after vacation.
Mr. H.L. Sangresu, Learned Senior Counsel, appearing for the appellant, and Mr. Ndishalai, Learned AG, appearing for the state respondent. This court, by its order dated 1/12/2023, had allowed the parties to try to forge out an amicable settlement as far as the dispute between the parties is concerned. However, the Learned AG has submitted at the bar that there is no possibility of settlement at this point of time,
Yes.
and has made a prayer for this matter to be heard on merit. The Learned Senior Counsel, appearing for the appellant, has no objection to the same and has also agreed that this matter to be heard on merit. Accordingly, this matter to immediately after the vacation.
This is your lordship. Lordship, I'll seek your lordship permission also. We would like to file a misapplication, your lordship, because the land has been donated by the red appellant along with the village Dorbar. Those village Dorbar, they are not before your lordship. We would like to implement them also.
That you can do.
Lordship.
In due time you can do, and the matter will be taken up.
Lordship.
That liberty is there with you.
Lordship will do. Sunday will
No
do
need,
that.
no
Lordship.
permission is required.
Apply, your lordship.
May I please, Your Lordship? I beg to mention item number 9 from the main case.
You are for
Order.
appellant.
Yes, sir.
No objection.
On pre-made by the appellant. This is matter to vacation.
Obliged.
May I please, Your Lordship, I beg to mention item number 7 from the names.
My lord, no objection, my lord. In fact, we have already filed our additional affidavit also.
What's this case about?
This is about compensation of land, Your Lordship.
Oh.
Where
On pre-made by the petitioner. This is matter to vacation.
much obliged.
My lord, I beg to mention item number 2, my lord, the main list. My lord. My lord.
Yes, what is this case about?
Lordship, that this is a case.
Cancellation of lease, my lord.
It's not a cancellation of lease, Your Lordship. The lease was granted. It had already expired long time back.
Oh,
Your
that
Lordship.
forest thing.
Forest
My lord,
colony, yes, Your Lordship.
So interim order is there,
No, my
There
lord,
is no
there's no
interim order, Your Lordship.
but that lease has not been renewed.
It has not been renewed since 1968.
Is there any eviction process?
No, not yet, my lord.
Lordship?
So you are asking
Lordship, because government is going to resume the land.
Let it come up to vacation, my lord.
on pre-made by the petitioner. This is matter to vacation.
Item 3 also connected with item number 2, my lord.
3 connected.
Connected.
Same order.
My lord, the similar prayer for item number 4 and 5, my lord.
4 and 5. They are also similar.
My lord.
You are there.
Yes, ma'am, for the state respondent, yes, both the cases.
On pre-made by the petitioner. Not objected to by respondent. This is matter to vacation.
Obliged.
My lord, I beg to mention item 8, my lord. Here in this matter, my lord, we were required to file the affidavit of service, which we are filing it in the course of the day, my lord.
Oh, on respondent 4.
Yes, yes, my lord. And besides that, we were also required to file rejoinder, my lord. I'm praying if this matter could be fixed after vacation, my lord. In the meantime, we'll file our rejoinder also.
You're for petitioner.
Yes, my lord.
On pre-made by
Lordship, I'm appearing for respondent number 1 and 2, Lordship.
fine. On pre-made by petitioner. This is matter to vacation.
May please, Lordship, I beg to mention item number 10.
On pre-made by petitioner. This is matter to vacation.
Obliged, Lordship.
Your Lordship, I beg to mention one unlisted matter. Actually, this matter was listed on the 13th this month before the bench of the acting Chief Justice. However, on that day, he was on leave. So there's some urgency. We filed one application from Ms. Kies to stay one impugn public announcement. So, Your Lordship, may kindly take up this matter because there's some urgency.
What is the urgency?
Your Lordship may brief the fact of the case. The case is that, Your Lordship, here I am the headman of Maungap Klichnong, and Your Lordship, the respondent number 2, which is the Lingdo of the Moplang, they removed me from the post of headman without complying the discouncil rule. And Your Lordship, thereafter we filed a petition, and has been admitted, and it's still pending adjudication till now, Your Lordship. And Your Lordship, during the pendency of this petition, they have issued me a legal notice to hand over all the keys, the audit register, and all the documents pertaining to the office of the headman of Maungap Klichnong. And thereafter, Your Lordship, we have also replied to the legal notice issued by them. And thereafter, Your Lordship, it has come to knowledge of the petitioner or the petitioner that the respondent number 2 is still interfering with the post of headman in Mau Klishnong. So, Your Lordship, there is also one public announcement that they have illegally removed me from the post of headman. So, Your Lordship, with regard to this case, I have filed this application to steer the imping announcement dated 23/12/2022, Lordship. So, Your Lordship, because
23/12.
Yes, Lordship.
Notice is dated what?
The imping announcement is 23/12/2022, Lordship.
22.
Yes,
But
Lordship.
now it's almost 1 year.
Yes, Lordship. So, Your Lordship.
Where is the urgency?
Just kindly take into consideration, I'll apprise more, Your Lordship.
Since the matter has already been heard
Yes,
by
yes,
the
Lordship.
competent court, it is still proceeding.
Yes, Lordship.
When is the next date fixed?
Oh, Your Lordship, the last date was fixed on the Wednesday.
It's fixed on this coming Wednesday.
No, Your Lordship. This last Wednesday, this Wednesday, the 30th, the 13th.
No.
Yes.
When is the next date fixed?
Till date also we haven't got any.
I think it'll be better you mention
Before the other bench.
Because you see, it's just a matter of 1 or 2 days.
Yes, Lordship.
By 19.
Okay, Lordship.
Any conflicting order may not be proper.
Yes, Lordship.
Judicial propriety would
okay,
demand that.
I'll do that, Lordship. Highly obliged.
And remember, in law, nothing can stop anything that is done to be undone.
Yes, yes.
Or anything that is undone to be done. That is the principle.
Yes, Lordship. Highly obliged.
Supplementary cost list, item number 1.
Okay, sir. Okay. Your appeal is here today.
May I please, Your Lordship? This is a bail application. I'm seeking bail for the petitioner, Your Lordship, on 3 grounds. Obviously,
Please,
this.
Lordship, before I learn his senior thoughts, I'd like to point out that Lordship cause title. Lordship, the petitioner has raised state of Meghalaya represented by senior government advocate, Lordship, and the IO.
So, is it wrong?
Lordship,
You see, the government advocate don't represent. The government advocate would fight for on behalf of the government.
My lord.
But he is not represented. It is the department concerned. If you say state of Meghalaya means state of Meghalaya in general.
Yes, sir.
Could be some department, home department, police department, political department, or so on and so forth. But it's not.
My lord, on
not
the
government
previous occasion, I have come before Your Lordship.
Now it has been pointed out.
My lord, I'll keep in mind, Your Lordship.
You have to correct this.
I'll correct it, my lord. May I?
Since it has offended Mr. Harwanlang.
I'm just pointing out.
He is the additional senior government advocate, not the senior. Please continue. But please do the correction. And allow you to correct.
When will this matter come out?
No.
Tomorrow, man.
You can correct in due course.
My lord.
Make a submission.
Oh, yes, Your Lordship. May I please, Your Lordship? Your Lordship, this bail application I'm preferring on 3 grounds, my lord. Of course, the case is under 21C and 29 of NDPS Act. So, rigor of 37 is there, my lord.
Exactly.
But I'm making out a case, Your Lordship, here. First ground, my lord, is that the accused is not guilty of the offence alleged. Second ground, my lord, the weight of the contraband seized, my lord, is highly disputed. And number 3, my lord, the sampling of the contraband is faulty. On these 3 grounds, I'm moving this bail application, my lord. So may I come to the first point, Your Lordship, how the petitioner is not guilty, my lord. My lord, this is a case, Your Lordship, where the petitioner is a professional bus driver and he drives bus from Assam, Hailakandi to Guwahati every day. Now, on the 5th of September, my lord, 2023, in the similar way, he was driving this bus from Hailakandi and proceeding towards Guwahati, and on reaching Nongpo, my lord, the bus was intercepted by the police. A thorough checking was conducted and a bag was found, my lord. A blue color bag was found from the seat number 28 or above the seat number 28 in the luggage cabin, my lord. And none was claiming that bag. None of the passengers, my lord. Thereafter, my lord, the police reopened the bag and found 30 numbers of soap cases. And in those soap cases, my lord, contraband was found. Now, the case of the prosecution is not that. The bag was found from the cabin of the bus, where the driver usually sits, or beneath his seat. It was found from a seat number, particular seat number. Passengers was there. All the passengers were let go. None of the passengers were interrogated. And a presumption was drawn, my lord, that because these people, bus drivers, they were operating this bus, so they are responsible. And they were implicated in this case, Your Lordship. So this is my first ground. It was not found either from the physical position of the petitioner or constructive position, my lord. It was found from the seat number 28. Now coming to the second point, my lord, the contraband seized, Your Lordship, is highly disputed. As much as, if Your Lordship will come to annexure 3, that is the FIR, my lord. Page number 21.
Yes.
The type copy, my lord, is subsequent annexure 3A, but I think this is quite audible, my lord?
Yes.
Your lordship, I have already marked here, if your lordship will get that point. The suspected contraband was emptied from the soap cases into one empty polythene bag, and the same was weighed, and the weight of the suspected contraband is 0.93 grams. The total weight of suspected contraband after deducting the weight of the polythene bag is 0.921 grams. Now, my lord, this is less than 1 gram. 0.921 grams. Now, I'll take your lordship to annexure 4, page 24, my lord. This is weight and measurement certificate. Page 24, weight and measurement certificate. The type copy, my lord, is at page 25. If your lordship will come, hence the total weight contraband 0.921 grams, less than 1 gram. Then again, I'll take your lordship to page number 26, which is a forwarding report, my lord. Even here, if your lordship will see, I have marked, on weighing the total weight of the suspected contraband is 0.921 grams. Again, I'll take your lordship to page number 27. Now, this is your lordship, again, it's another forwarding report. Here, on weighing the total weight of the suspected contraband is 0.921 grams. So, all this document reflects, Your Honor, Your Lordship, that the contraband is less than 1 gram. And as per the chart, the small quantity is 5 grams, up to 5 grams. Commercial quantity is 250 grams. So this is a case of small quantity, Your Lordship. How they have registered a case under 21C? It should have been 21A. All these documents, clearly, there is no ambiguity in these documents, Your Lordship. Clearly indicates that it is 0.21 grams. With this ground, I approached the trial court, my lord. Trial court has called the IO concerned and questioned him, and he said that by mistake I have written this. Now that mistake was taken into consideration by trial court, my lord. And I was completely thrown out. It is a settled position of law, my lord. If there is a doubt, the doubt always goes in favor of the accused. But here, the doubt went into favor of the prosecution, and she rejected my bail application, my lord. Then subsequent to that, my lord, I filed another bail application, taking another ground. And that ground, your lordship, is faulty sampling of the contraband. I will take your lordship to the FIR itself, page 21. If your lordship will see, that same paragraph which I have mentioned earlier, your lordship, the suspected contraband was emptied from the soap cases into one empty polythene bag, and the same was weighed, so and so. Now, what has the IO done, my lord? He has collected all the 30 soap cases and took all the contrabands and transferred it into one polythene bag. And from there, he picked up a sample, which is not permissible as per law. May I take your lordship to rules, NDPS Seizure, Storage, Sampling and Disposal Rules 2022, my lord. This is the rules, my lord. The narcotic, drugs and psychotropic substance seizure, storage, sampling and disposal rules.
Yes, my
lord.
They are in this compilation.
My lord, this is a act. I'm reading from the same act, my lord. This.
The running 2023. Can it 2020? You have a copy with you?
I have only one copy. Your Lordship can go through that. My Lord, my only contention here, my Lord, Rule 10.
Yes.
Your Lordship can go through that.
Get it out. We have a 2020 edition, so
my Lord,
I don't have that.
My Lord, Rule 10 of this rule states, Your Lordship, that how the sampling should be done. It says that one sample in duplicate shall be drawn from each package and container seized. 30 soap cases were seized, my Lord. From every container, sample has to be drawn. But in this case, my Lord,
you see, Mr. Matsuri,
My
those are all eventually a matter of evidence.
Correct, my Lord, no doubt.
So
but here, you know, I'm just trying.
Here we are only concerned with
Bill.
prima facie evidence.
Yes, my Lord.
The fact that you see alleged contraband, drugs was seized.
My Lord.
That is good enough.
Yes, yes.
And quantity is already given. So
Yes, my Lord.
Not necessary to go into all those things.
No, my Lord. I'm just trying to converse on this point, my Lord, for the reason. For the reason, my Lord, there is a Delhi High Court judgment. On this ground, the bail was granted. On this ground, my Lord. May I take your Lordship to where I have marked it on the second last page, your Lordship. Second last page. Para 8, if your Lordship has got that.
Yes.
Yes. I am of the view that as mandated by Honorable Supreme Court in Judgment of Union of India versus Balmukund others so and so, Standing Order 188 has been opined to be requirement of the law. The 3-bench judgment of Balmukund is binding on this court. Relevant portion of the Standing Order 188 read as under. In the case of seizure of single package container, one sample in duplicate shall be drawn. Normally, it is advisable to draw one sample in duplicate from each packet container in case of seizure of more than one package container. The Standing Order 188 mandates that the transferring of content of all packets into one and then drawing a sample from the mixture is not permitted, my Lord. I am of the view that in the present case, the instruction in 188 has not been followed and the sample has been drawn after mixing the content of various packets into one container. The same has caused serious prejudice to the case of the applicant. Since the collection of sample itself is faulty, the rigor of section 37 is not applicable, my Lord. The applicant is in custody since so and has no criminal antecedent. He has no criminal cases of any nature pending against him. For the aforesaid reason, I am inclined to allow the application. The applicant is entitled to be released on bail. Now, my Lord.
What's your object to this judgment, Lordship? It's not reported, nor is it cited anywhere. Lordship, this can be taken off from anywhere.
Fine, then you give an affidavit stating that this is not the judgment passed by the Delhi High Court. Give an affidavit. Serve an affidavit to that extent.
Mr. Farola, what is this?
This is online, my Lord, online judgments.
You're saying that this is a manufactured?
Manufactured?
Lordship was cited anywhere, but Lordship is now practice would be like.
So you give an affidavit to that effect, no? That I have manufactured it. It's online is there, my Lord. It's available online.
You give a proper. Should I see?
How can he object to a judgment I'm citing, my Lord? He can open the internet everywhere. It's available, my Lord. It's available on internet on one click on Google.
Where is this standing orders 1 of 88?
My Lord, standing order is here. Here I have a standing order also, my Lord. This is 1 of 89. If your Lordship will come to...
Give him a copy.
He will say again, I have manufactured it.
Maybe not.
If your Lordship will come to page number 3, I have marked it, your Lordship. All the drugs shall be properly classified, carefully weighed, and sample on the spot of the seizure. All the package containers shall be serially numbered and kept in lots of sampling. Sample from narcotics, drugs, and psychotropic substance seized shall be drawn on the spot of recovery in duplicate in the presence of the search witnesses and the person from whose possession the drug is recovered, and a mention to this effect should invariably be made in Panchnama drawn on the spot. The quantity to be drawn, that is okay, my lord. Now 2.4 is our case. In the case of seizure of single package container, one sample in duplicate shall be drawn. Normally it is advisable to draw one sample from each package container in case of seizure of more than one package container.
Yes, Mr. Yes,
My lord.
Excuse me. This this will be unconventional, but Mr. Paul, sorry, it just struck me. Sorry, the order that I passed is I have not imposed conditions.
Lordship.
So I will impose the condition.
My lords, I guess as much, my lords. I thought that it might have skipped your lordship's mind.
I think.
My lords. The bail would have to be accepted by the CGM also.
Oh, that of course, that's a different thing.
Lordship.
But since you are here,
Lord.
Sorry.
Grateful, my lords.
Yes, Mr. Please continue.
My lord, see, point number 2.4, your lordship, is our case where it is clearly mentioned that one sample has to be drawn from each and every container. In this case, admittedly, your lordship, the contraband was transferred from all these 30 soap cases into one polythene bag, and from there the sample was drawn. So it is a violation of the standing order, my lord. And that judgment clearly states, your lordship, that once there is a violation, faulty sampling, the rigor of section 37 does not apply.
But why you have not referred to this judgment of Bal Mukut?
My lord, this was more clearer in my case because it's completely
fine. Charge sheet has been filed?
No, not as yet, my lord.
Oh, 10. No charge sheet filed?
No charge sheet, my lord.
Yes, Mr. Kavala, what do you have to say?
Please, Lordship. Lordship, may take your Lordship to page number 12 of the Lordship, with regards to the quantity of the substance, Lordship, it was clarified that in the first paragraph, Lordship, the IO was called for explanation on the register section in connection with the instant case, and he stated that mistakenly he has shown that the net weight of the contraband as 0.921 grams, which should have been shown as 0.921 kgs. Next paragraph, Lordship. Heard learned PP who submits that the Panchnama and order dated so and so passed by learned JMC at the time of drawing of the samples of the contraband be produced by his court. As per said order of the JMC, 5 grams of was drawn, which clearly indicates that if the contraband is less than 1 gram, how can the sample of 5 grams be drawn from the presence of magistrate? So and so. Which is in consonance with the this standing order, Lordship, which is at point 2.3. The quantity to be drawn in each sample for chemical test shall not be less than 5 grams in spec of all narcotic drugs and so on so, Lordship. Hence, we have gone as per the standing order, Lordship.
Standing order, where is it?
Lordship, the standing order which minus.
Yes, I mean, you're referring to which?
2.3, Lordship.
2.3. Yes,
the quantity
should
to
not
be
be less
drawn
than.
in each sample for chemical test shall not be less than 5 grams in respect of all
But
narcotics.
if the seizure is less than 5 grams, then what happened?
Then, Lordship, I think the seized drugs in our package shall be, Lordship, if it's less than thing, Lordship, I'm still just, I think it should be somewhere around here. But even though, Lordship, the IO has clarified that is less than thing, and the learned special court has and the learned special court has accordingly given the order at page number 13, Lordship. The contention raised by defense that the case shall fall under category of small quantity cannot be accepted at this stage pending trial of the case, as much as statement of the magistrate in presence of whom samples were drawn, if recorded during evidence, is admissible as evidence in the court, and the burden of proving that contraband recovered falls under small quantity is on the accused. Also,
Yes.
Lordship, and also, Lordship, I'll take my Lordship to the Supreme Court judgment of in the Union of India versus Ajit Kumar Singh, where at paragraph 16, Lordship, Honorable Court has stated that in view of the above provisions, it is implicit that no person accused of an offence involving trade of commercial quantity of narcotics is liable to be released on bail unless the court is satisfied that there are reasonable grounds for believing that he is not guilty of such an offence and that he is not likely to commit offence while on bail.
This is the requirement of section 37.
Lordship. And your Lordship, if we're going by section 37, Lordship, then Lordship, this judgment of claim says that bail shall not be given, Lordship. And your Lordship has also given a judgment on 8 December, Lordship, in bail application number 61 of 2023, where Lordship was pleased to reject the bail in intermediate quantity, Lordship.
Yes.
If I can take a Lordship to paragraph number 13. May I take Lordship?
Yes.
The learned AAG has also referred to some authorities relate to the subject matter discussed here, more particularly the case of Union of India versus Aram Samuch and others reported in 1999 SAC 4229, wherein at paragraph 7 of the same, the Honorable Supreme Court has observed as follows. It is to be borne in mind that the aforesaid legislative mandate is required to be adhered to and followed. It should be borne in mind that in a murder case, the accused commits murder of 1 or 2 persons, while those persons who are dealing in narcotic drugs are instrumental in causing death, inflicting blows to a number of innocent young victims who are vulnerable. It causes deleterious effect and deadly impact on the society. They are a hazard to society even if they are released temporarily. In probability, they would continue their nefarious activities of trafficking and or dealing intoxicants constantly. Reason may be large stake and illegal profit involved. This court dealing with the contention that with regards to punishment and under NDPS Act has succinctly observed about the adverse effect of such activities in Duran Diden and versus Chief Secretary Union of Goa 1990 1 SEC 95 as under. With deep concern, we may point out that the organized activities of the underworld and the clandestine smuggling of narcotic drugs and substances into the country and illegal trafficking in such drugs and substances have led to drug addiction among among a sizable section of the public. Particularly, the adolescents and students of both sexes and menaces has assumed a serious and alarming proportion in the recent years. Therefore, in order to effectively control and eradicate this proliferating and booming, devastating menace, causing deleterious effect and deadly impact on society as a whole, the Parliament, in wisdom, has made effective provisions by introducing this Act 81 of 1985, specifying mandatory minimum imprisonment and fine. And I take your lordship to paragraph number 16. On perusal of the evidence already deduced, a copy of such deposition being produced before this court, it is clear that the accused person is very much aware of the fact that he is in possession of such illegal contrabands, and in spite of denial, therefore, at this juncture, he cannot escape the privacy. His complicity in this case is well established as to will not depend on the appreciation of the body of evidence by trial at the end of the trial. Suffice it to say that the purpose of application of ground of bail, the court is convinced that no case has been made out of the out in this regard. Lordship, in both these cases, if Lordship is convinced that is an intermediate case, Lordship, the case has been made out that that drugs has been taken from possession of this of the accused, and also Lordship in right now is also put the lower court below has also produced that it is a matter of self-evidence, Lordship, that and the IOs also stated that is a commercial quantity, Lordship, and hence the rigors of 37 will be applicable to this case.
Yes. My lord, my only contention is the judgment which he has read, passed by your lordship. There, the contraband was found from the position of the accused. Here, your lordship, is a clear case. He is just a driver. How would he know the identity of the passenger or his luggage, for that matter? Your lordship is well aware. Night super buses has no link with the passengers. They are just supposed to drive the bus. Had the bag found in the driver's cabin or beneath his seat, then there was a question of constructive possession. But here, it is not even constructive. Physical is out of question. It is not even constructive, my lord. So it's a clear case, my lord, that the fault of the IO concerned. He should have interrogated those persons who were sitting in the seat number 28. Admitted position, my lord.
He is the only one who was arrested.
There are two drivers, my lord, in this case. Night super buses, they always go with two drivers and one handyman. Okay. One handyman is there and two drivers. One driver was sleeping and the other driver was driving at that point of time, my lord. And the petitioner was driving. The other driver was resting. That is the time when this entire seizure took place. Now, it is very clear case, my lord. Seat number 28, there is a passenger on that. Why not interrogated him? Why not? Presumption should have been on him.
Heard Mr. N. M. Mansuri, learned counsel for the petitioner. Also heard Mr. H. Karonlang, learned additional senior GA for the state respondent. The learned counsel for the petitioner submitted that an FIR was filed on 5/10/2023 before the officer in charge, Nongpo PS, Riboi District, full form to PS, wherein it has been indicated therein that a vehicle suspected to be carrying contraband was intercepted. Where was it intercepted?
At Nongpo, my lord.
Oh, Lordship, next to this
Soil and Water Conservation Office.
Intercepted at, I think here it says NH06. Is it NH06?
Yes, my lord.
In front of Nongpop, yes.
Nongpop, yes, my lord.
In front of Nongpop, yes. The same being a night super, number AS24 AC1151. On a search being conducted, one unclaimed blue color bag was found from the bunker of the bus, and on checking, it is found that 30 numbers of different colored soap cases containing suspected contraband, probably heroin, were recovered. The contents of the said alleged contraband substance was emptied into an empty polythene bag, and the same was the weight coming to about 0.930 grams, and after deducting the weight of the polythene bag, the same came to about 0.921 grams. The police then apprehended the one or two have been arrested here.
3, my lord.
3 suspected persons, and a regular and a police case was registered as Nongpop PS case number 11510 of 2023 under section 21C/29 NDPS Act. An investigation was accordingly launched. It is also the submission of the learned counsel that it's the petitioner himself who is the accused.
Yes, my lord.
The petitioner, who is the driver of the said bus, was arrested with no evidence of his being involved in the alleged offence, inasmuch as the petitioner is the bus driver, not connected with what goes on in the said bus as regard the passengers, and since the alleged contraband substance was found from the overhead bunker of seat number 28, most probably it could most probably the same belong to the passenger of the said seat number 28. However, the police have let off all the passengers and have arrested only the petitioner and the co-driver and another. Who is the other one?
Handyman, madam.
And the handyman of the said bus. As the learned counsel has has reiterated that since the alleged seizure was not made from the possession of the petitioner herein, therefore nothing can be attributed to the petitioner as far as the alleged offence is concerned. The second limb of argument advanced by the learned counsel is that the FIR and the subsequent forwarding report filed by the IO before the competent authority has time and again indicated that the total weight of the suspected contraband is 0.921 gram, and as such the quantity seized is a small quantity under the relevant provision of the NDPS Act, particularly section 20 or 21?
21.
21. The rigors of section 37 therefore would not be applicable as far as the prayer for grant of bail in the case of the petitioner is prayer of grant of bail in the case of the petitioner is concerned. The third limb of argument advanced by the learned counsel is that the manner in which the sampling was carried out at the time when the alleged suspected contraband was seized is a clear violation of the relevant rules, inasmuch as in the FIR itself it was indicated that the suspected, I quote now, indicated that this, I quote down to, the suspected contraband was emptied from the soap cases into one empty polythene bag, and the same was weighed, and the weight of the suspected contraband is 0.930 grams. Stop. The total weight of suspected contraband after deducting the weight of polythene bag is 0.921 grams. The manner in which the sampling was done is a clear violation of the relevant standing order. Where is that standing order?
One of 59, Your Lordship.
Standing order 1 of 89.
89, my lord.
But the Delhi High Court says 1 of 88.
It's same, my lord. Actually, some modification was done in 89. It is same.
Standing order 1 of 89.
Relevant is 2.4, Your Lordship.
Just which standing order was issued pursuant to section 52A of the NDPS Act 1985, and the, what's the rule again?
2.4, my lord.
No, the relevant rules that
or rules,
you
my
are
lord.
quoting the rule.
This is
kunum tukong to the last one. One 59. And the provision of Rule 10 under Chapter 3 of the Narcotic Drugs and Psychotropic Substances under bracket seizure, comma, storage, comma, sampling and disposal, close bracket, rules 2022, wherein Rule 10.2 provides that when the packages and containers seized together are of identical size and weight, bearing identical marking, and the contents of each package gives identical results. No. What is the relevant portion?
10.1, no, my lord.
10.1. On one sample in duplicate shall be drawn from each package and container seized. Since the procedure was not followed, therefore, on this count too, the petitioner is entitled to be enlarged on bail. Reference is made to the case of Lakshman Thakur versus State under bracket government GOBT dot of should be NCT of Delhi, wherein by order dated 14/12/2022 in bail application 3233/2022, the Honorable High Court of Delhi, in an application for bail, has enlarged the accused on bail, taking into consideration that the sampling of the seized contraband good was not done as per the relevant rules, which procedure is a requirement of law, the same being confirmed by the Honorable Supreme Court in the case of Union of India versus Bal Mukund, KUND Mukund and others, 2009-12 SEC 161. On this ground alone, the Honorable Delhi High Court has granted bail, opining that the rigors of Section 37 of the NDPS Act will not be applicable. In view of the submission made herein above, the Learned Counsel has submitted that the petition will be allowed and the petitioner will be enlarged on bail on any condition that is deemed fit and proper to be imposed by this court. Per contra, Mr. A.H. Karwalang has submitted that a reference made to the alleged seizure, that is 0.921 grams, was a mistake committed by the IO, which has been acknowledged by the trial court, by the court of, where is that order?
Court of Special Judge, no problem.
Lordship, at page number 12, second paragraph.
Page 12.
Lordship.
Kunumtungo, by the court of the London Special Judge, NDPS, Rivoy District, in its order dated 14/11/2023, on an application for bail preferred by the petitioner herein and others and other co-accused. The Learned Special Judge in the said order had observed that the IO was called for explanation, and he has stated before the court that it was that mistakenly he had shown the net weight of the contraband as 0.21 grams, which should have been shown as 0.921 kgs. In the same order, it was also observed that as per the order of the Learned JMFC, 5 grams of sample was drawn. 5 grams of sample was drawn, which clearly indicates that if the contraband is less than 1 gram, the same could not have been done so. Therefore, the clarification as to the actual weight of the seized contraband substance has been clarified before a competent authority, not less than the special court and DPS. As such,
Lordship, I missed one point. Panchnama also, Lordship, is recorded as 9 to 1 grams, Lordship. I missed that point, Lordship. My apologies.
Panchnama 9 to 1 grams.
Yes, Lordship. Page number 32.
Yes, everywhere it has been noted 9 to 1. So that obviously must have been a mistake. The Learned Additional Senior G has also submitted that in cases of this kind involving the provisions of the NDPS Act, be it seizure of intermediate quantity or commercial quantity, this court has more often than not taken the view that the presence and the danger of contraband substances or narcotic drugs circulating within the state does not augurs well for the well-being of the citizen, particularly the younger generation who are susceptible to be lured into consumption of such illegal substances, which will in turn result in addiction and complication, both physically and legally. Reference has also been made to the case of Srimati Savitri Chetri alias Kali Chetri versus State of Meghalaya, wherein by order dated 8/12/2023 in BA number 61 of 2023, this court at para 13 of the same has referred to the case of Union of India versus Ram, Samuj and another, reported in 1999 9 SEC 429, para 7, and has opined that the menace of drug has to be eradicated from our society. Eradicated from our society in whatever means possible, though the same should be done as per in accordance with law. It is prayed that this petition has no merit and the same be dismissed. This court has given due consideration to the submission made and has also taken into account the submission advanced by the learned counsel for the petitioner as regard the weight of the seized contraband substance. Though the records would show that an amount of 0.921 under bracket 10 net amount 0.921 grams under bracket net has been seized and sample taken accordingly, the explanation of the learned counsel, learned additional CAGA, referring to a related order of the learned special judge in this matter, would found favor with this court, inasmuch as it is but logical that if suspected contraband substances have been seized from contained in 9 soap cases, by no stretch of the imagination can the cumulative of the contents of all the 9 soap cases would weigh only about 0.921 grams. It is incumbent upon the IO to clarify this point in course of investigation. Be that as it may, this court is convinced that the seizure could not have been 9.21 grams, but perhaps more than that. As to the manner in which the seizure the seized contraband was the sampling, the process of sampling, the process and procedure of the sampling of the seized, of the alleged seized contraband substance is concerned. The prior the submission of the learned counsel for the petitioner has substance. However,
may I please know?
This
Lordship, almost small submission. Lordship, in this case, Lordship, in as per the signing order or 1 num of 89 Lordship, as per my reading Lordship, 2.5 will be applicable in Lordship, because the case in the Delhi matter Lordship, as per my reading Lordship, because 2.4 will be applicable only in the Delhi case, because as per paragraph number 3 Lordship of the Delhi judgment, Mary, as per the said seizure memo, 12 kgs ganja recovered from 6 packets in possession of Ajit Kumar were mixed with 5 packets of 2 kg each. Lordship, may I read 2.4 of the signing order, Lordship? In case of seizure of single package container, one sample duplicate shall be drawn. Normally, it is advisable to be drawn from one sample from each case of more than one package. Lordship, these are in matters where the packages are different. Lordship, may I read 2.5 now? However, when packages containers seized together are of identical size and weight, bearing identical markings and contents of the each package given identical results on color, thus by the drug identification kit conclusively indicating the packages are identical in all respects. The packages containers may be carefully bunched in lots of 10 packages containing, except in the case of ganja hashish, except in the cases of ganja hashish, where it may be bunched in lots of 40 packages, so on and so forth. Hence, Lordship, as if I can take Lordships to the punch nama, Lordship, at page number 32. The sampling was done in accordance with 2.5, Lordship. May I read, Lordship, from 1, 2, 3, 6 line from the top, Lordship. Further, all 30 soap cases suspected drugs, may I read, Lordship?
Yes, yes.
Are transferred to the transparent polythene bag and weighed in a drawing machine, and total weight of the suspected drugs is 21 grams. Moreover, the preliminary test was so and so forth, which small amount of suspected drugs was taken into small scale testing drug so and so is mixed with a drop of reagent is mixed into it turned into purple, which is positive for result for heroin. Hence, Lordship, it was done, Lordship. So all these packages of same packages were found and they were dumped into a thing, and hence they were, I think, Lordship, in accordance with 2.5.
At this juncture,
My lord, my learned friend has not understood the concept. What I was trying to say before this court is that you cannot taste by transferring all the contrabands in one container. That is the law. You have to test from each container. 30 soap cases were there. Everything transferred into one.
But 2.5 is...
Exactly, that is what it speaks. You read it properly, you'll understand.
no, this is what is indicated here is the manner in which the sampling
Has to be conducted.
Whether they are bunched together.
That is bunching part will come, my lord, later.
If they are identical, then they are bunched together. If they are in different of different color or different substance, then you cannot mix them together and
my
sample.
Yes, my lord.
No. Next. However, with deep respect to the authority cited, this court would maintain that the provision of section 37 would be applicable as far as this instant case is concerned. And under such circumstances, this court is not convinced that the petitioner is innocent of the alleged that prima facie the petitioner is innocent of the offence alleged against him. It is also brought to the notice of this court that the process of investigation is still ongoing. In view thereof, this court finds that there is no merit in this petition, seems to dismiss. Petition disposed of.
I oblige.
Obliged.
Item number 3.
Is your book? Sorry.
May I please, Lordship?
Yes.
Lordship, on earlier occasion, the learned prosecutor has submitted that one case is pending, NDPS case is pending against me. So, in this regard, Lordship, I may be allowed to produce, place on record before your Lordship the acquittal order and as another related documents, Lordship. So, Lordship, from page 1 to 4 is the FIR. Page 1 to 4 is the FIR. My apology, Lordship, I could not translate the copy because this morning I have received this soft copy, Lordship. These are the certified photocopy, Lordship. So, Lordship, kindly come to page 2. That is the FIR number, Lordship, and that is 419/2016 under section 326, read with section 22 of NDPS Act. And
you're reading to receive.
Lordship,
not so clear.
This is the PS number, Lordship. 419/2016 under section 326 IPC, read with section 22 of NDPS Act. And Lordship, page 5 is the seizure memo. Page 5 is the seizure memo, where Lordship 2 numbers of cough syrup was recovered and one knife length 6 so and so with plastic handle was recovered. And from page 6 to 8 is the copy of the charge sheet, photocopy of the charge sheet. From 6 to 8 is the photocopy of the charge sheet. And page 9 is the acquittal order. Page 9 is the acquittal order.
Yes.
So in the preface is written, Lordship, case number GR 2272/2016 arising out of Luckipur PS case number 419/2016. So I may be allowed to take your Lordship to page 10. That is the photo certified copy. Now in this case, since offence has already been explained and subsequent to that the withdrawal petition has been allowed in this case, therefore the accused person Jangir Alam is acquitted for the offence under section 324 IPC as per section 321B of CRPC. So Lordship, this is an acquittal order, Lordship.
No, but he was acquitted only under section.
Yes, Lordship, from the entire case, Lordship.
But the case is also, you see,
Yes, yes, case is also
I
been
think,
dropped against him.
Again, under section 21 or 22 of the.
Probably, Lordship, during the framing of charge, I do not have that copy of that order. Framing of charge, because Lordship, my allegation was that I was selling cough syrup, and 2 bottles of cough syrup was recovered. That the allegation was that, and probably during the framing of charge, section 22 was dropped, Lordship. I do not have that copy of that order.
Anyway, that is just to prove the antecedent.
He was acquitted. This is a case of 2016, right? And he was acquitted only
Lordship.
for the offence under section under the IPC. The offence under NDPS, it remains. Right?
We don't know.
Acquittal order is 24/3/2023.
I don't think, you see, acquittal would be piecemeal.
Yes.
Once you are acquitted,
Once acquitted.
Perhaps what Mr. Deb is saying is correct. See, we don't know. We don't have the records with us. If the charge sheet is produced, perhaps prima facie case was found only under section 324. Could be.
Because earlier, Lordship, he was arrested for selling ban cough syrup. Ban cough syrup. He was arrested, and also, Lordship, after he came out from jail, he was again involved in this smuggling, drug smuggling, in 2003, 2023. This 2023 is different case.
Only allegation. I've been acquitted in 2020-23, March 2022.
Here is 21 C is involved.
Yes, Your Lordship.
Commercial quantity.
Yes, Your Lordship.
But this is 2016 case.
But Lordship, from my position, nothing was recovered, either from physical provision or from.
Who are you?
I'm Lordship. They are claiming that I'm the supplier.
So,
me,
what is your,
I myself have filed the bail application, Lordship.
What are you? What is your profession? Are you a driver or?
I'm doing small business, Lordship.
You're doing small business.
Yes, seasonal business.
So from where seizure was made?
Seizure was made, Lordship, from
just please
near Khaliat PS.
Please, just go back to the facts of the case.
Yes, Lordship.
Refresh this court.
Lordship, the seizure was made near that's Lordship, page 15. That is the FIR, Lordship. Page 15. Page 16, Lordship, type copy. Is the page 16 type copy. So, Lordship, I may be allowed to read, Lordship. Yes. With reference to the subject cited above, I am to inform you that on the 19th June 2023 at around 4:30 p.m., confidential source information was received from Shri B. Jirua, MPS Additional SP East Jenta Hills, Khaliat, that 2 drug peddlers, namely Shri so-and-so, are traveling in a tourist vehicles, Tata Winger, bearing registration number so-and-so, and are carrying a consignment of illegal contraband in the vehicle to deliver to a supplier named Jahangir Alam and Shanohar Ali at Guwahati. Immediately, the ANTF team and staff of Lat Rimbai outpost, along with 2 independent witnesses, set up a Naka at BMFS fuel station Nong Sing. At around 5:40 p.m., the tourist vehicle Tata Winger was detained along with the 2 occupants. Accordingly, search of the vehicle was conducted in the presence of independent witnesses, and 200 soap cases containing yellowish orange powder were found concealed in various hidden compartments in the vehicle. Preliminary test of the powder gave a positive result for heroin. The total gross weight was found to be 2.738 kilogram. So thereafter, Lordship, I was arrested. I was arrested on Lordship. I was arrested on 31st August 2023. So Lordship, kindly come to Annexure 2, page Lordship 20. That is the type copy, Lordship. Page 19 is the arrest memo, and the operative part is page 20. Yes. At Lordship, serial number 13, name and address of the witness. At least 1 witness is necessary. Here, Lordship, it has been witnessed by UBC 88 R. Suchiyang, led by POP EJH SD. So, Lordship, this arrest, Lordship, my arrest was totally illegal. As per the ratio laid down by the Honorable Supreme Court in Dikebasu case versus State Bengal, that is, Lordship, 1997, Volume 1, SCC 416, Lordship. Paragraph 35.
(1997).
Yes, Lordship. Paragraph 35.
2009. You're referring to this 2009.
Lordship, 1997, Volume 1, SCC 416.
This is another case.
Dikebasu.
This is 2009-12 SCC 161.
My mistake. Yes, sorry, my mistake. Paragraph 35. It is saying that, Lordship, we therefore considered it appropriate to issue the following requirements to be followed in all cases of arrest or detention till legal provisions are made in their behalf as preventive measures. The Lordship, I'm just reading the relevant portion, Lordship.
Yes.
That is point number 2, Lordship. That the police officer carrying out the arrest of the ST shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall also be countersigned by the arrestee and shall certain the time and date of arrest. Here, Lordship, it has been attested by the police, Lordship. Besides, Lordship, section 41B of CRPC, 41B CRPC, Lordship, subsection B, Lordship, is also written. Prepare a, this is, Lordship, procedure of arrest and duties of officer making. Lordship, 41B CRPC, Lordship. Procedure of arrest and duties of officer making arrest. I'm just reading clause B. Prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or respectable member of the locality where the arrest is made. So, Lordship, my humble submission is that the arrest memo here in, Lordship, was prepared by one police personnel.
Yes.
And the same is apparent in the arrest memo itself. That is, it's not in accordance with law. So therefore, Lordship, I pray that my bail application may be considered. This is one of the ground, Lordship. And another ground, Lordship, that as per the Panchnama, Lordship, kindly come to page 9 of my petition, Lordship. Paragraph 7.
Yes.
That as per the Panchnama, seizure memo and charge sheet, it was alleged that a total of 2.738 kilogram contraband was seized containing in 200 soaps in different proportion, and the same was marked as Exhibit A, consisting of A1 to A5, Exhibit B consisting of B1 to B50, and Exhibit C consisting of C1 to C50, and Exhibit D consisting of D1 to D50, and to this effect, on 26/6/23, a certificate as required under section 51A, subsection 2, clause A and C of the NDPS Act was also prepared. So, Lordship, kindly come to page 33. That is the Panchnama, and the type copy is at page 36, Lordship.
Yes.
And operative part is at page 37.
Yes.
So they are saying, Lordship, accordingly each bunch or weigh with a detailed scale as under A1 to A50 total weight is 7.3 gram and so on, so Lordship.
Yes.
And annexure 5, page 39 is the seizure memo, Lordship. So at serial number 7, they are saying that 738 kg of suspected heroin and 200 empty soap boxes were recovered, they are saying. And Lordship, page 40, annexure 6. So they have given that the details that each box is containing how much the contraband, Lordship. They have given the details. That is A1 containing 13.84 grams and so and so, Lordship. That is till page 48, Lordship. Now, Lordship, they have prepared one inventory report also, Lordship. That is annexure 7. Annexure 7, page 49.
Yes.
Most respectfully, with reference to the above and in compliance to the Honorable Court order dated so and so, I beg to report and submit herewith the inventory report of the drawal of samples exhibits of heroin as follows. So, Lordship, in for exhibit A consisting of A21, A2, A50, weight about 668.45 grams. They have taken sample of 3.34 grams of heroin. So accordingly, they have taken, Lordship, for each of the bunches. There are 4 bunches, so they have taken. So Lordship, kindly come to page 9 of my petition.
Yes.
Paragraph 8, Lordship, I may be allowed to read.
Yes.
That it is submitted that on 26/6/2023 an inventory report was also prepared and the samples exhibits was drawn in presence of the learned judicial magistrate first class for the FSL test, and the same are as follows. Exhibit A1, 3.34 of 34 grams of heroin. Exhibit B1, 3.55 grams of heroin. Exhibit C1, 3.54 grams of heroin, and exhibit D1 is 3.54 grams of heroin. Further, in FSL report, it was found that the exhibit marked as DN 634/23A, DN 634/23B, DN 634/23C, and DN 63/23D gave positive test for so and so, and their percentages are found to be 14.66% and so respectively. However, it is pertinent to mention that it was alleged that a total of 2.738 kilogram contraband was seized containing in 200 soaps in different proportion, but the sample was collected only to the extent of A1, that is 3.34 grams, exhibit B1 3.55 grams, exhibit C1 3.54 grams, and exhibit D1 3.54 grams, that is total of 7.75 grams, excluding the weight of empty transparent plastic. And as such, it is evident that the samples from each soap was taken for the purpose of the FSL test, and eventually it reveals that the alleged contraband was not of commercial quantity. Therefore, Section 21C of the NDPS Act is not attracted, and that being the position, and also there being otherwise no recovery from the petitioner accused, and the quantity in question being intermediate quantity, the rigors of Section 37 of the NDPS Act do not apply to the present case, as held by the Honorable Supreme Court in Criminal Appeal Number 923 of 2020-22, State of West Bengal versus Rakesh Singh, and eventually the petitioner accused placed to release him on bail. Lordship, in this regard, Lordship, I may be allowed to place one decision of the Madhya Pradesh High Court.
You mean to say that the see the weight
Yes.
of the sample is to be taken?
Yes, yes.
Whether it is commercial or intermediate or small quantity?
No, my condition is that they said that from me they have recovered 200 soaps, and each soaps containing different proportion of contraband. But when they have sent the samples, they have collected in one piece of contraband. They have given. They have just collected it as a whole, not as different like A1, A2, A3. They have not collected. They have collected as a whole. They have said that, Lordship, I may be allowed to take your Lordship to page 37 of the that is the Panchnama. That is A1 to A50. Total weight is 703 grams.
Yeah.
But in the certificate which they have prepared under section 58(2) of the NDPS Act, they are saying that A1 containing different proportion, A2 containing different proportion. But while they have taken the samples for FSL, they have taken as a whole, Lordship. So they.
What about this B, C, and D?
They are taken in a small proportion. They have not taken for each A1, A2. They have not taken. They have taken as a whole. They have collected in maybe in a box. The prosecutor will be in a better position to know how they have collected. It seems they have collected in one box, then they have taken from. But in the certificate which they have issued under section 52 of the NDPS Act, they are saying that the contraband was found in different proportion in 200 soaps. They said that. But while collecting the samples, they have not did from each soap. They have collected as a whole from A1, then A2, Lordship, B1, C1, D1, like this. So in this connection, Lordship, I may be allowed to place one decision of the Honorable Madhya Pradesh High Court, Lordship. So, Lordship, I may be allowed to read page 3. Page 3.
Just a moment.
It is a very recent decision, Lordship.
Order is dated?
Order is dated, Lordship, is it's not here, but 5th December 2022. On the top, Lordship. Just after Honorable Justice Deepak Kumar.
Yes.
So I may be allowed to read, Lordship, page 3, paragraph number 2, Lordship. From the side of appellant accused, it has been submitted that investigating agency committed gross negligence during investigation because before taking sample of each package, they mixed the contraband kept in 50 packets. In fact, they had to take the sample from each package. In support of contention, learned counsel for applicant accused has relied on judgment passed by the High Court of Judicature for Rajasthan at Jodhpur, so-and-so, on 16/5/2019, in which the same facts were taken into consideration. In that case, SHO Police Station Arnaud District, Pratapgarh, seized 1264 kg and 800 gram popsy husk containing in 57 bags. Seizure officer first mixed all the poppy husk contained in 57 bags on a trampoline and thereafter took 2 samples of 1 kg from bag number 1. The Apex Court in Netram versus State of Rajasthan reported in 2014 (1) Criminal Law Journal Rajasthan 163 has held that if the samples from each bag containing poppy straw have not been collected and test by U and kit has not been conducted on each bag and if the seizure officer has taken out some quantity of narcotic drug from each bag and after mixing the same has taken out some portion for sample, then the sample is not in conformity with the standing instruction number 1/88 issued by the Narcotics Control Bureau, New Delhi, particularly instruction number 1.7, and as such, it cannot be said that the narcotic contraband recovered in the matter is of commercial quantity or above. Learned counsel for the applicant placed a reliance upon criminal miscase bail application number so-and-so, passed by High Court of Judicature at Allahabad, Lucknow bench, wherein para 6 and 11 it has been held. Learned counsel for the applicant has submitted that the general procedure for sampling provided in Standing Order number 1 of 1989, dated 13/6/1989, has not been complied by the opposite party. He has relied upon clause 2.1 to 2.8 of the aforesaid standing order quoted herein below. All drugs shall be classified carefully, weighed and sampled and on the spot of seizure. All the packages containers shall be numbered and kept in lots for sampling. Samples from the narcotic drugs and psychotropic substances seized shall be drawn on the spot of recovery in duplicate and in the presence of such witnesses, panchas, and the persons from whose possession the drug is recovered and mentioned to this effect should invariably be made in the panchnama drawn on the spot. The quantity to be drawn in each sample for chemical test shall not be less than 5 grams. In respect of all narcotic drug and psychotropic substances, save in cases of opium, ganja, and charas, hashish, where a quantity of 24 grams in each case is required for chemical test. The same quantity shall be taken for the duplicate sample also. The seized drugs in packages containers shall be well mixed to make it homogeneous and representative before the sample is drawn. In the case of seizure of a single package container, one sample in duplicate shall be drawn. Normally, it is advisable to draw one sample from each package container. However, the packages containers seized together are of identical size and weight, bearing identical markings, and the contents of each package given identical results on color test by the drug identification kit, conclusively indicating that packages are identical in all respects. The packages container may be carefully bunched in lots of 10 package containers, except in the case of ganja and hashish, where it may be bunched in lots of 40 such packages containers. For each such lot of packages containers, one sample in duplicate may be drawn, where after making such lots, in the case of hashish and ganja, less than 20 packages container remain in, and in the 4 case of other drugs, less than 5 packages containers remain in, no bunch would be necessary and no samples need be drawn. If such remainder is 5 or more in the case of other drugs and substances, and 20 or more in the case of ganja and hashish, one more sample may be drawn for such remainder package container. While drawing one sample from a particular lot, it must be ensured that representative sample that the in equal quantity is taken from each package container of that lot and mixed together to make a composite whole from which the sample are drawn from that lot. The apex court in case of Noor Aga versus State of Punjab has held in paragraphs number 123, 124 and 125 that the standing order in dispute and other guidelines issued by the authority having legal sanction are required to be complied by attesting authorities. For ready reference, the aforesaid paragraphs are quoted below. So, Lordship, I'm not going to this.
Just trying to, what are you trying to point out?
I'm trying to.
These are the rules.
Yes, Lordship.
The rules have been violated.
Yes, Lordship. And besides, Lordship, I also rely on one decision of the Honorable Apex Court, Lordship. That is 2009, volume 12, SCC 161, Lordship. 2009-12, SCC 106, paragraph 36.
Yes.
There is another paragraph 36, Lordship. There is another aspect of the matter which cannot also be lost sight of. Standing instruction 1/88, which had been issued under the Act, lays down the procedure for taking samples. The High Court has noticed that PW7 had taken samples of 25 grams for each from all the 5 bags and then mixed them and sent to the library. There is nothing to show that adequate quantity from each bag had taken. It was a requirement in law. So in my case also that is not followed, Lordship. Besides, Lordship, I place on record on some compilation of decision of the Honorable Supreme Court. That is, Lordship, serial number 1, that is reported in AR 1993 SC 1456. The Honorable Supreme Court holds that we shall first consider whether the prosecution has established beyond all reasonable doubt that the accused had in his possession 2 pieces of charas weighing 7 grams and 5 grams respectively. As already mentioned, only one piece was sent for chemical analysis, and PW1, the junior scientific officer, who examined the same, found it to contain charas, but it was less than 5 grams. From this report alone, it cannot be presumed or inferred that the substance in other piece weighing 7 grams also contain charas. It has to be borne in mind that the Act applies to certain narcotics, drugs and psychotropic substances and not all other kinds of intoxicating substances. In any event, in the absence of positive proof that both the pieces recovered from the accused contain charas only, it is not safe to hold that 12 grams of charas was recovered from the accused. In view of the evidence of PW1, it must be held that the prosecution has proved positively that charas weighing about 4.570 grams was recovered from the accused. The failure to send the other piece has given rise to this inference. We have to observe that to obviate this difficulty, the concerned authorities would do better if they send the entire quantity seized for chemical analysis, so that there may not be any dispute of this nature regarding the quantity seized. If it is not practicable in a given case to send the entire quantity, then sufficient quantity by way of samples from each of the packets of pieces recovered should be sent for chemical examination under regular punchnama and as per the provisions of law. Lordship, I also place on record, Lordship, the NDPS Rule 2020-22. Rule 3, Lordship. It is saying the classification of seized material. The narcotic, drugs, psychotropic substances and controlled substances seized under the Act shall be classified based on physical properties and results of the drug detection case, and if any, and shall be weighed separately.
Yes.
If the narcotic, drugs, psychotropic substances and controlled substances are found in packages or containers, such packages and containers shall be weighed separately and serially numbered for the purpose of identification. In my case, nothing was done, Lordship. Now, Lordship, kindly come to Rule 10, Lordship.
Yes.
Sub-Rule 1. Rule 10, Sub-Rule 1, it is saying that one sample in duplicate shall be drawn from each package and container seized. Rule 10, Sub-Rule 1.
Yes.
It is saying one sample in duplicate shall be drawn from each package and container seized. So nothing was done, Lordship, here. Similarly, Lordship, Rule 11, quantity to be drawn for sampling. Except in cases of opium, ganja and charas, where a quantity of not less than 24 grams shall be drawn from each sample. In all other cases, not less than 5 grams shall be drawn for each sample, and the same quantity shall be taken for the duplicate sample. The seized substances in the packages or contents shall be well mixed to make it homogeneous and representative before the sample in duplicate. So these rules were never followed in my case, Lordship. So this is also one of the ground for my bail, Lordship. Now, Lordship, they are saying that from the PO they have recovered 2.738 kilogram of contraband, which they suspect to be a heroin. However, Lordship, nothing was recovered from me. In fact, I was not there at the PO when the recovery was made. So, Lordship, it's a settled law that whereas possession of the contraband is a sine qua non under section 21 of the NDPS Act, and as such it is prayed to this honorable court to release the petitioner accused on bail. So, Lordship, I place reliance on one decision of the honorable Apex Court, that is, Lordship, in my compilation serial number 3, that is 2011 volume 12 SCC 2007. In my compilation, serial number 3, State of Delhi versus Rama Akhtar alias Rama.
Yes.
2011 volume 12 SCC 2007. The Honorable Court hold that to secure a conviction under section 21 of the NDPS Act, possession of the illicit article is a sine qua non. Such article should be recovered in accordance with the provision of section 50 of the NDPS Act. Otherwise, the recovery itself shall stand initiated in law. Serial number 4, that is, Lordship, Noor Agha versus State of Punjab, 2008 volume 16 SCC 407. At paragraph number 59, it was held that with a view to bring within its purview the requirement of section 54 of the Act, element of possession of the contraband was essential so as to shift the burden on the accused. The provisions being exception to the rule, the generality thereof would continue to be operative, namely the element of possession will have to be proved beyond reasonable doubt. I have been charge sheeted under section 21C and 29 of the NDPS Act, Lordship. Further, Lordship, they have claimed, they have found my involvement in the instant case from the statement of the co-accused, Lordship, that the co-accused has stated that they were supposed to deliver the contraband to me. And firstly, Lordship, in this regard, I may be allowed to place reliance on one decision of the Honorable Supreme Court, that is, in my compilation serial number 5, Tufan Singh versus State of Tamil Nadu, 2021 volume 4 SCC 1, at paragraph number 155.
Yes.
The Honorable Apex Court hold that thus to arrive at the conclusion that a confessional statement made before an officer designated under section 42 or section 53 can be the base to convict a person under the NDPS Act without any non-obstinate clause doing away with section 25 of the Evidence Act and without any safeguards would be a direct infringement of the constitutional guarantees contained in Article 14, 20 within bracket 3 and 21 of the Constitution of India. We answered the reference by stating that the officers who have invested with powers under section 53 of the NDPS Act are police officers within the meaning of section 25 of the Evidence Act, as a result of which any confessional statement made to them would be barred under the provision of section 25 of the Evidence Act and cannot be taken into account in order to convict an accused under the NDPS Act. That a statement recorded under section 67 of the NDPS Act cannot be used as a confessional statement in the trial of an offence under the NDPS Act. Further, in criminal appeal number 1136 of 2014, that is serial number 6 of my compilation, Lordship, the Honorable Apex Court hold that Any confessional statement made by an accused to an officer invested with the powers under Section 53 of the NDPS Act is barred for the reason that such officers are police officers within the meaning of Section 25 of the Evidence Act. A statement made by an accused and recorded under Section 67 of the NDPS Act cannot be used as a confessional statement in the trial of an offence under the NDPS Act. So, Lordship, further they have alleged that I am in constant touch with the co-accused, and I am in constant touch by two SIM card numbers. That is, Lordship, kindly come to page 10 of my bail petition, Lordship. Page number 10, paragraph 10.
Paragraph 10.
Paragraph 10. It may be mentioned that in the charge sheet it has been alleged that on the disclosure of the statement of the co-accused and the CDR, that is called details record, pertaining to the SIM card number so and so, the petitioner accused was arrested, and eventually a charge sheet under Section 21C 29 of the NDPS Act was filed against the petitioner accused along with two other accused. However, it is explicitly submitted that it is a settled law that any statement made under Section 161 of the CRPC and under Section 67 of the NDPS Act are inadmissible in the eye of law. Nevertheless, the petitioner accused was arrested. Further, it is also respectfully submitted that neither the SIM cards number so and so nor any mobile phone was seized by the police from the possession of the petitioner accused to substantiate that SIM cards number so and so belongs to the petitioner. Thus, there are no reasonable grounds for believing that the petitioner accused has abetted or conspired for the commission of the alleged crime, and as such it is prayed that the petitioner accused to be enlarged on bail. So, Lordship, in this ground, what is the reasonable ground the Honorable Apex Court has hold in State of Kerala versus Rajesh? That is, Lordship, in my compilation serial number 7, 2020-20, volume 12, SCC 122, at paragraph number 21.
Yes.
The expression reasonable grounds means something more than prima facie grounds. It contemplates substantial probable cause for believing that the accused is not guilty of the alleged offence. The reasonable belief contemplated in the provision requires existence of such facts and circumstances as are sufficient themselves to justify satisfaction that the accused is not guilty of the alleged offence. Now, Lordship, serial number 8, we may clarify that at the stage of examining an application for bail in the context of Section 37 of the Act, the court is not required to record a finding that the accused person is not guilty. The court is also not expected to weigh the evidence for arriving at a finding as to whether the accused has committed an offence under the NDPS Act or not. The entire exercise that the court is expected to undertake at this stage is for the limited purpose of releasing him on bail. Thus, the focus is on the ability of reasonable grounds for believing that the accused is not guilty of the offence that he has been charged with and is unlikely to commit an offence under the Act while on bail. Coming back to the facts of the instant case, the learned single judge of the High Court cannot be faulted for holding that the appellant NCB could not have relied on the confessional statement of the respondent and other co-accused recorded under Section 67 of the NDPS Act in the light of law laid down by three-judge bench of this court in Tufan Singh, wherein as per the majority decision a confessional statement recorded under Section 67 of the NDPS Act has been held to be inadmissible in the trial of an offence under the NDPS Act. Therefore, the admission made by the respondent while in the custody to the effect that he had illegally traded in narcotics drugs will have to be kept aside. Now, Lordship, I have on similar ground I also have filed bail application below the code below, Lordship. So that is annexure, and they have and my application was rejected by order dated 7/11/2023. That is annexure 9, page 51, Lordship.
That's one. Yes.
Page 51, Annexure 9. Lordship, kindly come to page 56, which is the operative portion of the rejection orders. Lordship. Firstly, Lordship, I may be allowed to read para number 1, 2, 3, 4, Lordship. In view of the submission,
Para 4?
In 4, Lordship, para number 4. In view of the submission, and page 56, Lordship.
Yes.
In view of the submissions put forth by both learned counsels representing the parties, I have carefully perused the materials on record, and it's seen that the accused herein was arrested in accordance to law as stated by the prosecution, and the question of illegality of arrest does not arise as his family member was informed about the arrest. So, Lordship, I have been informed. My family was informed about my arrest, but the proper procedure was not followed. That is section 41B, clause B, Lordship, subclause B of the CRPC, as well as the ratio laid down by the Honorable Supreme Court in DQ Basu judgment, Lordship. Now, Lordship, kindly come to page 57.
Yes.
Paragraph number 1, 2, 3, 5, Lordship. Paragraph number 5.
Yes.
Over and above, the contention of the defense to the other ground does not call for any intervention by this court now, and it is known fact that the burden of proof lies with the accused that he is not involved in the alleged offence, and fair chance will be given to him during trial of the case to bring out the truth. So, Lordship, the burden of proof initially, Lordship,
yes,
is on the prosecution, Lordship. I may be placed on record, Lordship, the decision of the Honorable Supreme Court. That is, Lordship, in my compilation, serial number 13, in Noor Aga versus State of Punjab, and another, the Honorable Supreme Court hold that at paragraph number 58, whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of section 35 of the Act, the actus reus, which is possession of contempt by the accused, cannot be said to have been established, Lordship. Now, Lordship, now another decision of the Honorable Supreme Court, I may be allowed to read, Lordship, that is serial number 12 of my compilation, Lordship. We may first test on the bail of settled law the plea taken by the learned counsel for the appellant, Satnam Singh, that the prosecution had failed to establish a prima facie case against the accused, and therefore the burden of proving his innocence did not shift back to him. In the case of Noor Aga, a two-judges bench of this court was required to decide several questions, including the constitutional validity of the NDPS Act and the standard and extent of burden of proof on the prosecution vis-a-vis the accused. After an extensive discussion, this court upheld the constitutional validity of the provisions of Section 35 and 54 of the NDPS Act, but went on to hold that since the provision of the NDPS Act and punishments prescribed therein are stringent, the extent of burden to prove the foundational facts as on the prosecution would have to be more onerous. The view taken was that courts would have to undertake a heightened scrutiny test and satisfy itself of proof beyond reasonable all doubt. Emphasis was laid on well-settled principle of criminal jurisprudence that more serious the offence, the stricter would be the degree of proof, and a higher degree of assurance would be necessary to convict an accused. Thus, it can be seen that the initial burden is cast on the prosecution to establish the essential factors on which its case is premised. After the prosecution discharges the said burden, the onus shifts to the accused to prove his innocence. However, the standard of proof required for the accused to prove his innocence is not pegged as high as expected of the prosecution lawsuit. In other words, in the words of Justice Sinha, who is speaking for the bench in Noor Aga, had observed that whereas the standard of proof required to prove the guilt of the accused on the prosecution is beyond all reasonable doubt, but it is preponderance of probability on the accused. If the prosecution fails to prove the foundational facts so as to attract the rigors of Section 35 of the Act, the actus reus, which is possession of contraband by the accused, cannot be said to have been established. The essence of the discussion in the caption case was that for attracting the provision of Section 54 of the NDPS Act, it is essential for the prosecution to establish the element of possession of contraband by the accused for the burden to shift to the accused to prove his innocence. This aspect of possession of contraband has to be proved by the prosecution beyond reasonable doubt. Now, Lordship, kindly come to page 58 of my petition.
Yes.
There is saying that the judgment cited in support of this application cannot be totally relied upon to release the accused at this juncture due to reasons cited above. So, Lordship, has been totally ignored the decision of the Honorable Supreme Court, Lordship, and the ratio laid down while deciding any NDPS case, Lordship. That's all.
Lordship, that earlier case, which he said he has been acquitted, Lordship, it was registered under IPC, read with NDPS, Lordship. If your Lordship come to page 3 of that paper, which he submitted.
Yes.
Page 3, Lordship. Yes, go on the top, Lordship. Under section 326 IPC.
No, that is okay, but see the operative portion where the court has acquitted the accused. No mention is made of the NDPS.
No mention is made about NDPS. The court has mentioned only 324 of IPC. So,
what do we cannot determine?
My submission is that this NDPS offence and NDPS Lordship, it remain. And Lordship, moreover, in my humble submission, how can a matter can be withdrawn during the trial, Lordship? During the trial, how can it be withdrawn during the trial? If at the stage of investigation, then that is different.
This is an observation by the court. This court cannot sit on judgment on that.
Yes.
It cannot even make observation. Matter has not come under appeal.
And Lordship, this is a case of 2016. This is the case of 2016. But in his statement, Lordship, he has mentioned about the case of the case which he was involved recently in 2023, Lordship. After he came out from jail, then he was again involved in drug smuggling.
Lordship, small rebuttal, Lordship. As my learned senior is stating that I have stated that my case is pending, one recent case is pending in the year 2020-23. But firstly, Lordship, the statement is not admissible. Secondly, Lordship, if it is so, I have been acquitted in the year 2020-23. Probably he has said that I have been acquitted in the year March 2023, and they have recorded that I have a case in the year 2023.
That is 2016 case, must be acquitted in 2023. But here in his statement, he has mentioned about his involvement in the drug smuggling in 2023, Lordship. Lordship, the statement is there in the case diary, Lordship.
It's written March 2023. March 2023, and I have been acquitted on March 2023. It's written March 2023, and I have been acquitted on March 2023. It is only a misconception, nothing, Lordship.
He was involved on 2 occasions, Lordship, even in 2003, recently in 2023, Lordship.
Apart from this case?
Apart from this case. This is the case of 2016.
No, forget what is 2016.
Yes, but recently in March 2023.
Yes.
After he came out from jail, he was again involved in drug smuggling.
Do you have the details?
In his statement, he has given his mention This is the case diary, in the case diary.
What did he say in his statement?
He said after he was out of jail, then in the month of March 2023, the key accused delivered to me 20 soap cases of heroin in Guwahati near city center shopping mall, which was wrapped with polythene plastic, and I paid amount of rupees 80,000 to Sri Lankumar. And again, after a month, I received 25 soap cases of heroin at Guwahati in the parking lot at the shopping mall, which I paid 1 lakh to Sri Lankumar.
No, so that statement is involved, is connected with this case.
This means he was not caught. I think for these two occasions he was not caught. It is his statement given to him to the investigation.
Maybe that is his statement, but nothing has. No FIR has been filed. No proceeding has.
But he has mentioned this in his during the investigation.
So that will be taken only. That will be reckoned with as far as this case is concerned.
Yes.
Lordship, I may be allowed to place one decision of the Honorable Supreme Court, as my learned senior is insisting that I was having a case. Lordship. That is, Lordship, 1997, Volume 3, SCC 268. Lordship, just paragraph 23. I have taken just an extract of the decision, Lordship. Paragraph 23. Although the judgment of the session judge is otherwise an exhaustive judgment, it cannot be said from the instances which we have set out above that his appreciation is free from legal infirmity of some kind of prejudice against the accused who are described as lawbreaker. In our system of law, an accused starts with a presumption of innocence. His bad character is not relevant unless he gives evidence of good character, in which case by rebuttal of bad character may be adduced.
Lordship, and one final.
And this matter is only for Khalirat case, Lordship. I'm not here for the Guwahati.
That is only to check his antecedent.
Yes,
Lordship, and all the seizure, Lordship, all the seizure is shown in the inventory certificate issued by the magistrate. So it is of the commercial quantity of 2.7.
Whether it was done as per the rules, Standing Order 1 of 88.
The Panchnama also, it shows that the total amount is 2.735 kg. So, Lordship, may produce the case diary also, Lordship. I flag all the statements and.
For the parties, I'll pass this yours.
Item number 4.
Item number 4, Lordship, this matter along. Yes, this appellant, Lordship, has.
Yes, who's for the
Mr.
That is our review petition, my lord.
This matter also, my lord, I'm praying if it can be come up immediately after vacation, my lord.
In that case, my lord, I may be allowed to file one misapplication because I may be reinstated back in the service, and they are always taking time in the last moment also.
Good file. Whatever that's on premier parties, this is matter to petition.
Nice. Bill costless, item number 1.
Made please, Lordship. Lordship, here, Lordship, one SLP criminal has been filed, being the diary number 5067 /2020, and the matter is under process for listing, Lordship. And probably the matter will be coming by 20.
You have details?
So, Only the matter has been filed, Lordship, and the diary number is 506.
Give me the complete details.
All right, Lordship. I will.
So I can note down. Huh?
All right. Diary number. I'm having only the diary number.
Is it SLP or
SLP criminal? Diary number being diary number 5067.
So we'll record that.
Yes.
Mr. VDAP Learned Counsel, petitioner has submitted that the matter pending before the Honorable Supreme Court being SLP
criminal
under bracket criminal
diary number
5067
5067 oblique 2023
is still pending, and as such this matter may be adjourned for the time being to await the order of the Honorable Supreme Court in the said SLP criminal in the above mentioned case. Accordingly, as prayed for, this matter after 8 weeks. All right.
Item number 6.
His Lordship, the conduct counsel KP Bhattacharjee. He was in the first half, but he has to leave for some personal difficulties. If this matter may be taken up after winter vacation, Your Lordship.
No objection, sir, but this very simple. It is regarding prayer for releasing of the fund pending with the Deputy Commissioner, Your Lordship. And the land also has been settled by the ownership has been settled by both the trial court and the appellate court of EM and CAM. And this land not only Nokma, but this plot of land where the BSF has established this BOP border outpost is belong to the petitioner, Your Lordship. So I don't have any objection of the application also. That case is coming on 20 of this month, Your Lordship. But that is also slightly different, not related to this case.
On premier by the Learned Counsel, on premier by the Learned GA appearing for the state respondent, the same not be objected to by the petitioner. Matters adjourned. This is the same application.
And highly obliged.